Hello, this is Antonio Gangale. I'll be discussing the book regarding the United States of America versus Union Cheese Company. Years ago, several of my friends had suggested that I should write a book regarding what transpired in the Union case. I really wasn't interested in doing it, and one keep insisting that I should write a book memorializing what transpired there. And I thought about it, and ultimately I thought I'd just write some notes and maybe kind of think about it. And I decided I would write a book, and I dedicated it to John Myers. He was an employee at Union, and a lot of the disputes with the Food and Drug Administration kind of evolved around some of his departments and things. John came and had a meeting with me after the supplemental order, and April 6th, he died by suicide. So during that conversation, we were dismayed of how the court came to some facts. And John's death definitely affected me. So I started kind of really thinking about doing a book and getting into things. So I was starting to do some notes and wasn't sure how I'd write the book. So a little back history so the FDA had conducted routine surveillance on the firm and took samples. The FDA notified of a positive test for Listeria mono. In response, the firm conducted a voluntary recall and would do sampling of the cheese before shipment. The FDA conducted follow-up inspections with extensive environmental surveillance. During the November 29th to the December 14th visit, a sampling discrepancy was uncovered. The cutting room supervisor assigned those duties was dismissed. That individual met with the Food and Drug Administration and alleged several things with the cutting room, the recall efforts, and some shipments. I was never mentioned in this affidavit. My mother was never mentioned. None of the production or operations individuals or staff were mentioned of any wrongdoing. We were never given the affidavit to dispute some of the facts. I don't believe this was submitted within the complaint. So I don't know if there was rebuttal of certain things or whatnot. You will notice, though, I was never mentioned in the case, and you'll see within the statements of fact that it appears to skew or misrepresent certain duties. So it appears that they intentionally skewed it. I'll further discover that again, I was not mentioned and I wasn't being given understanding of what was being filed or any of these things. So I'll discover in docket number 8, 11, and 13 that it clearly indicates to the court that there's wrong parties named, or there's improper parties, and there's problems with this complaint. So again, we were never given this affidavit at the time. So, and what's interesting about this affidavit is, so the federal investigators go and meet with the individual to obtain this affidavit or ask questions or whatever. And it would seem logical that during this course, if they're inquiring of any things or whatever, or put it in an affidavit, they would ask if there was other people, right? So my point is, so I was with the Food and Drug Administration basically 95% of the time while they're in the plant. So if you're asking for an affidavit and you want to get information of other people or whatever, you would think they would ask, well, hey, what about Mr. Antonio Gangale here? Do you have anything, especially if I'm with them and communicating with them, wouldn't you want to know any issues of integrity or whatnot? I believe there's evidence to show they skewed it. So after this testing discrepancy, the FDA was absolutely infuriated, and they began to aggressively mandate this. It was a zero tolerance policy of Listeria mono in the plant, and it was insisting that the 60-day aging period was ineffective at reducing pathogens. So they were clearly openly ignoring U.S. policy, which cheese can be made from unpasteurized milk, and the standards of identity of natural Swiss cheese. So that was really creating huge disputes between the FDA and the company. And so each day the investigation continued and intensified. They were wanting more stuff. Ultimately it became intolerable. And it appeared that the mandates that the FDA wanted appeared that they weren't going to be uniformly applied in the industry. and it appears that they were conflicting with well-established federal law. So these new policies, and while they're ignoring laws, the firm had asked them to obtain some type of inspection order, some type of warrant to continue their entry into the facility. So some of the things, and I'll get into further detail. So definitely the zero tolerance policy for Listeria mono in the processing area was a huge dispute that we were having. They were raising issues of the milk supply, the method and manner how we were of production. They wanted the brine pasteurized, the brine room separate and independent room. The wooden boxes they used for aging, they wanted something sanitizable. They wanted more frequency of tests throughout the whole plant. There was issues of how the separator, the discharge lines use certain things. They were insisting that there was cross-contamination in production, so all the issues of like gaskets. So there was a whole thing of leak through valves going over and things. So there was just a lot of disputes. So let me get into some of the things. So real quick is the inspections. They're supposed to be in reasonable times, within reasonable limits, reasonable manner, and reasonable promptness. So I think that there's issues there, and this is. So here's an interesting is. You'll see that milk, they're citing or they're having issue with certain things is like milk used to make cheese, which was stored in the silo of Union's production room. And you'll see here they're doing inline samples, raw silo. They're examining raw test records. So federal law provides that you could use it raw. They were testing the milk that's within the balance tank to the surge tank before the pasteurizer. So there's just certain oddities. And what I mean by that is, and at the time I did not know that the Food and Drug Administration actually published certain things. So there was a kind of an understanding. We knew that Listeria was ubiquitous and that there was probability that it comes in within the milk supply. But at the time, I had no idea that there were surveys by the FDA themselves that estimated that it was 12% of the ball raw milk is contaminated with Listeria mono. So here, the FDA knows Listeria is 12% probability, and they're testing inline products or in-process stuff where federal law says I can use it raw. So it would clearly indicate that if that product, there would be a 12% probability if federal law allows you to use it raw. And here and what's interesting about Union, is Union used a method. Now, this was before or during these inspections, we were going through the manner and method of production. And I had told the Food and Drug Administration that we heat treated the milk. And that we had a system, and you can examine the U.S. Department of Agriculture, which was before and then after the dispute, is we had it at 155 and we had 2-second hold times. So let me explain the process. It uses a process a little less invasive than full pasteurization, and it still tries to maintain certain enzymes in the milk, so you get a better flavor and whatnot. So here, this was published in Dairy Foods in May 1995, and this is during basically before the litigation. So firms use this. If you look through the Ohio statutes and federal, it's discussed. You'll see within the code here, cheese from and they'll use heat treat unpasteurized. So clearly the terminology and whatnot is used and it's understood. Now, during the inspections, the Food and Drug Administration was having issue wanting full pasteurization or a legally sealed certified device. So again, federal law provides that you can use it raw. We're doing a method very close to pasteurization. So during these nearly 3 weeks of investigation, we went over the whole entire device and raised the device to above legal pasteurization. So it was at 162, and I had 20-second hold times. So there's interesting is you'll check the EIR report or whatnot, but you'll see that there's equivalent time and temperature. So certain statutes cite that you can have equivalent to the bacterial destruction. And what's also is, here's the code, and you'll notice that the mandatory pasteurization is for final packaging form, and cheese making, you go through a process much further. So there's even question if the particular statute is applicable to cheesemakers, particularly, because you're inducing cultures during in your vat while you're still filling. So here you'll see this is within the court ordered or the court case. November, the ERI starts here. It says current inspection found deviations from good GMPs, good manufacturing process, which relate to microbiological control. The firm relies on aging of the cheese since the milk is not pasteurized. Well, there's a huge dispute if that's false information. Is there equivalent of that? And so if a court or whoever's doing the analysis, especially the expert witness, is not informed or whatever that we're doing this particular method, it could skew results considerably. So you see within this court order, here it has, man testified Listeria mono found in the cheese may have been introduced through unpasteurized milk or through the environment. Pasteurization kills off Listeria mono. Again, so he testifies pasteurization kills off Listeria. As an alternative to pasteurization, aging cheese for appropriate amount of time will kill off low levels, in here 100 CFUs per milliliter, but may not kill off high levels. So if you analyze certain things, or the expert witness is, does his system, the manner method that he's using and his system, does it kill it off? Further, if you examine other experts in the scientific literature, they use inoculated milk at 10 to the 4th to 10 to the 5th CFUs per milliliter, and it's killing it off. So his numbers are extremely low, and they seem to omit that Union has the method of using the high temperature short time at those temperatures. Again, so the Food and Drug Administration, during this inspections, they're refusing to accept the manner method that we were using. And if you go into further, you'll see is I don't believe any of they examined the blocks of cheese of after the 60-day aging period. They're always using the cutting room operations, which Union shipped out bulk cheese by the truckload. So they don't seem to analyze those particular results. However, they use testimony saying that it's ineffective in using these skewed results. Ultimately, we will test the 3,981 blocks, all tested free with Listeria. But let's get into more. Further, the standards of identity is when they publish those, it is what to reasonably expect. So what's weird about this zero tolerance policy is it's at any detectable level. So does this mandate comply with what law was on the books of reasonableness? Let's go further. The FDA was insisting that the brine be pasteurized, and we would ask, well, and once we pasteurized it on, I believe it was a Sunday, you see, this is the records here, and you see it was at 185. So they wanted it done frequently. So we pumped down, we sanitized the room, the brine, or pasteurized the brine, and cleaned the tank and sanitized the tank. So they were starting to say, well, we want it frequently. So you'd press harder, or you'd ask more, well, what do you consider free? Like, what do you want, or how? And then it would go further and be like, well, if you break production, by the rule of thumb, it would trigger a sanitation requirement. So they'd be like, if every day do you wash your lines of milk lines? Do you make vats every time you use it? Do you wash the vats? Does the separators get washed? So you go through the list of all the things that you do when you break production or the sanitation requirements. They're expecting that with the brine. Now, for those that have any clue, this is a huge. You look through the brines throughout the industry. These are huge rooms that are holding cheese. And for you to pump down every day and sanitize it, it would almost require you to have a secondary system, multiple rooms, or you'd be stopping production, or huge deviations of how you normally run a facility. So, and these are huge brines, and so it would be considerable infrastructure for companies to do this. So this was a dispute that we were having. Also, when the cheese left the brine, it's typical that you would rinse or have some fluid or dip the cheese before it goes into packaging. So in here, Swiss is rind and rindless. So people, during the process of rind cheese, they actually even wash and clean the block. So there's issues that if they're alleging that there's something wrong or whatever, what's the dose, what's the defect level rate, and is it possible what we call conditioning. So again, we were having these huge disputes with the Food and Drug Administration regarding that. These wooden boxes. So it was an industry size of these blocks of cheese, and it was typical of having wooden boxes to use. So the FDA wanted the no wooden boxes, and they should be sanitized or cleaned. They shall be cleaned after each use. So, but these wooden boxes are industry standards. So when a cutting company orders huge amounts of cheese, we would load it up with blocks of cheese, and sometimes you would have returns, and it would be from another facility and get return boxes, and they would be from different companies. So here, if you're requiring one company to have these some type of plastic or alternative means of that, it was considerable cost, and so there were thousands of dollars. And I think if you bought the molds and had them do it themselves, like buy the molds to have them crafted, I think the molds themselves were either $80,000 or $100,000. But anyway, but the FDA, they wouldn't accept the wood. Well, you'll notice there was a court-ordered inspection, and they didn't find Listeria mono. However, during the inspections and things, they would insist that you not only have to fix the violations, you have to prevent it from occurring. So that was causing a lot of disputes. So when this court case happened, again, I wasn't mentioned or named in the litigation, so I wasn't sure. And from who they were named, it seemed, and then when you consider here that the surveys by the estimate that about 12% of the ball raw milk is contaminated with Listeria mono, and you consider that federal law provided that you could actually use raw milk, so it seemed to me that it was clear that there was zero tolerance policy, and what existing law was that there's conflicting things. So I thought the court was going to make guidance of, well, this is what you do regarding the pasteurizer, this is what you do regarding the brine, this is what you'll do with the wooden boxes. So I really thought that the order was going to explain what we were the disputes that we were having. Well, that's not really what happened. So if you examine the court order, you'll see defendants, Union Cheese Company Corporation, Dominic F. Gangale and M. Gangale individuals, and all the officer, director, agents, representatives, employees, attorneys, heir assigners, successors, and any and all persons in active concert or participation with them. Goes on, unless and until defendants have established and implemented adequate methods, facilities, and controls for receiving, manufacturing, preparing, packaging, distributing, and holding articles of food in the facility to ensure that the food is not contaminated with Listeria mono bacteria, other pathogenic bacteria, or filth. Such methods, facilities, and controls shall specifically include, but not shall be limited to, the following. So this court mandated zero Listeria, and it went further to include other pathogenic bacteria. And again, here you see receiving or manufacturing, preparing or packaging. So you have to understand is like when you package cheese, it's like 30 hours into it, or when you put it in the brine, you're at like 15 hours. And then there's 60 days beyond that. So this is you can't even receive. It just seemed completely out there. Then it's for a period of 1 year, as frequently as the FDA, and you find in defendant's cheese food processing or storage environment of the order an additional year from the date of such discovery and as frequently as the FDA deemed necessary. So this order was extremely oppressive. And this was under threat of civil or criminal contempt. So you'll see here, here's the order and the mandates. And we'll go just quickly through of the things that were required of this company to continue operations. And again, this is under threat of contempt if you violate this order. So here's the supplemental order and what's interesting is all the provisions of the June 6th remain in full force and effect, were expressly modified by the supplemental order. Further, what's interesting is here there's this case called Public Citizens versus Heckler. And that's when the courts determined the standards of identity for milk and required the certain legal pasteurization of milk. Now, what's interesting about this case is, so the FDA had conducted the Administrative Procedures Act and had public comment, and they weren't making decisions or they stayed the implementation of it. What's unique about this case is, so if the if you know Public Citizens versus Heckler and the case law or kind of what transpired in that case is, so when the judge came to its findings of fact and mandates, and you're not to receive, you're not to manufacture, and what does that go against the standards of identity of Natural Swiss and the rights or privilege of using unpasteurized milk? So does it conflict? Does zero tolerance conflict with the existing federal law? And if it does, is the judge blowing through the standards of identity, and is he completely destroying that particular law? And if he is you would think if zero tolerance policy, if that mandate is now case law in the law of the United States, wouldn't they be required to publish it in the Federal Registry according to the court's opinion within a 90-day period of the order? So, and what's interesting is, so there was the television interview on January 22nd. And during that interview, he had said, it only is affecting one plant. Well, the order may be affecting only one plant, but this zero tolerance is a case law now, and it actually should be affecting the entire country. Further, within that interview, the FDA had made comments that all I need to do was certain things, and then when you read the order here, it's clearly much more than what they were leading on to. Let's get back to John and the reason why, or dedicate the book to, is so did the FDA, are the rights and privileges of people, the Administrative Procedures Act, are people entitled to be heard before the government makes an opinion? Were their rights violated, or was the process how this judge came to its findings? See, and so when you think about John or the people within production, where you have a federal court pointing fingers at a certain department saying, well, it's clear that you guys are the problem here. And that's absolute bullshit. Is what due process do people have that this court's pointing fingers at? So, and it appears to us that it completely goes against federal law. So we were very confused of how in the hell did this court come to its findings, and are they like the certain laws, and when is this going to start affecting other facilities or whatnot? So there was just a lot of confusion of this particular order. Well, you see in this case, but here, irreparable deprivation of procedural rights to protected parties' concrete interest is irreparable injury. So here, and that was regarding deviations from the Administrative Procedures Act. So here, is it irreparable harm when the government does not follow the Administrative Procedures Act in determining this zero tolerance? And let's go a little further. So this zero tolerance, it's not within the federal registry or whatnot. So you don't understand, or it's hard to determine where did this zero tolerance policy come from when there's clear established existing law on the books that you can use actually even raw milk. So there's this whole confusion of this order. But it goes further, is this order possible? It's 12% of the commercial milk supply. So if you're bringing in milk on a daily basis, we brought it in every day, you have a 12% probability. And this is under threat of civil or criminal contempt. And every time you test a positive, it's for another year. So here, this is on June 22nd, one of my co-ops out of New York had called me trying to come to a resolution with the Food and Drug Administration of these mandates and whatnot, or how we would comply with this order. And I had a discussion with it. It was like, this is, I don't think we can comply. Like, this, we won't agree to these mandates. It's just, you're under civil and criminal contempt. Like, it doesn't seem, or, there's a lot of things that we'd have to hammer out for us to really do this. Anyway, so we're having these conversations at the beginning of the day. Here, he calls, this is within his affidavit, calls the Food and Drug Administration trying to come to some resolution. And you'll notice here, it says, during one conversation with Charles Cedric, and that's the person in charge of compliance, he states that it was going to be virtually impossible for Mr. Gangale to resume his Swiss cheese manufacturing operations. Now remember, they did a goddamn interview earlier, or during the same period of time, the same date, same period. So there's conflicting things of what they were saying publicly and what they were doing privately. And it appears that the Food and Drug Administration knew that this order was virtually impossible. And when they say virtually impossible, is it like near infinitely impossible? Because it's not only Listeria mono, it's other pathogens, and it's throughout the whole entire damn facility. So is this order possible? And why that's important is because if this order is not possible, then the successor corporation, how in the hell did the FDA sign off on the successor corporation if it's virtually impossible? How did the successor corporation certify that they're compliant? How did their experts and whoever, a specialist, tell you that they're complying? Goes further, is not only is it the successor corporation, is that order included under Rule 65, is it C? Any and all persons enact a concert or participation with them. So, is there issues that the suppliers, the distributors, and whatnot, are they a party and bound by the court order? So, if it's not possible, how in the hell are they complying with this? So, there was huge things regarding that I was discovering with the book. So, I was in the process of doing the book, and so there was a lot of things, and so I was debating if I should publish or whatnot, and I believed that there was willfully depriving of certain rights and privileges within this case, or there was just an enormous amount of things and other things with the book. So again, ultimately I didn't want it. And, well, there's much more about the book, but this video is getting a little long, so I don't want to get into too much. Here, I'll send it, make sure everything's... So here, I was going to get it reviewed. I believe that there was fraud and misrepresentation and false declarations within the case. And I believe that there's issues that the court lacked subject matter jurisdiction, and also I believe that there was willfully depriving of rights or privileges. I believe that this order is not possible, or virtually impossible, and it would require that if it's not possible for successors and whatnot to explain. Further, I believe that the Administrative Procedures Act was violated. I believe that zero tolerance policy, I believe the federal court did not have jurisdiction to make the rulings, or it did not comply with the Administrative Procedures Act, with the public's right to be heard. I believe that there is misrepresentation and perjury regarding material facts. I believe them claiming that adulteration, and if they don't meet the threshold of adulteration, you can't use injunctive relief. So I believe that it was skewed and misrepresented. And I believe the U.S. attorneys, the duty of candor to a tribunal and representations to the court. So at no point did they correct the record. So I believe that there's issues there. I believe that there was misrepresentations of the manner and method, particularly of the heat treat method, and also his analysis. I believe he skewed it. And there's the huge issue of improper parties named. So you're litigating things within this case, however, they don't have the proper parties named, and it appears that they intentionally skewed it for that reason. And from the conversations I had during the court order inspection, as well as the June 22nd call that the co-op out of New York had, which he explained things, it is clear that there was some type of skewing or whatnot and intent by the Food and Drug Administration. And there's issues of what the Justice Department then and the court knew as well. There's clearly some shenanigans going on, and I believe that there was misconduct, and I believe there was willful deprivation of rights and issues of conspiracy to deprive against rights. There's issues, I think, of the equal application of the law and what is the law. Further, that they would raise issues of Qualtam cases is if this made case law and this is the standard, then there are a lot of people that it would appear to be in violation of this mandate. I believe that there's federal questions whether there was discrimination or harassment by government actors within Union Cheese Company, whether there was criminal conduct by the government in the U.S. versus Union Cheese Company case and related events, whether there was willfully depriving of rights under the color of law, and if there was conspiracy to deprive rights under the color of law, and whether the June 16th order is actually void, were the requisites for a valid judgment met, and that would require persons with interest to be adjudicated must be given adequate notice of the proceedings and an opportunity to be heard. Further, the court must have authority in adjudicating the type of controversy presented. This authority is generally referred to as subject matter jurisdiction. So I believe that there's issues that the court did not have authority to determine the zero tolerance policy. I believe it conflicted with well-established federal law. So one of the issues is the zero tolerance policy, is that order, is it being complied with? Or was it being complied with? And that's where, so you'll see here, I will be named as an interested party. I believe I would be named in 2006 within one of these cases here that I raised issues regarding the union case, because if the court lacks subject matter jurisdiction, that it can be attacked or raised at any time. So if there was fraud or failure to join proper parties or an indispensable party was not named, the court lacks subject matter jurisdiction. So there should be legal issue right that I should be able to collaterally attack and to raise issues regarding that. However, you'll see in this case here, the Northern District Court did an extraordinary event. In that case, Antonio C. Gangale filed pro se petition for redress of grievances pursuant to United States First Amendment. Petitioner is adjourned from filing any new lawsuits or other documents with the court. So without hearing, without any right to be heard, nothing, I'm permanently barred the use of the Northern District Court. So are there massive legal issues within that case, creating massive legal issues throughout all other cases that I have certain rights or privileges or protections that I should be able to enforce? So presently, let's get back to the book. I still debating on the book. I have a lot of it written. I believe that there was not a fair and impartial administration of justice. in the case. I don't believe there was a fair trial. I believe the judge did not follow the law, and in multiple cases, a judge should accord every person who has a legal interest in the proceedings a full right to be heard. I don't think he complied with the judge did not comply with the law here on multiple things. I'm still debating about the book. Got a lot of information and kind of curious if you think I should finish the book or wait, because there's clear legal issues that should be resolved and things. So I'm getting close to what I should do with the book. I want to thank you for your time.